Well, good morning, everybody, and welcome to this meeting of the FDIC Board. I'd like to call the meeting to order. We have several items on the summary agenda this morning. Are there any questions or comments on the summary agenda? If none, may I have a motion to approve the summary agenda?
So moved.
Thank you very much. I note that both Director Su and Director Chopra have made a motion, and a second.
Second.
Thank you very much. That's Director Su. I'll now call the roll for the vote on the summary agenda. Director Su?
Aye.
Director Chopra?
Aye.
And I will vote aye as well. The motion is adopted. We have one item on the discussion agenda this morning. It is a memorandum and resolution regarding a final rule on false advertising, misrepresentation of insured status, and misuse of the FDIC's name or logo. Seth Rosebrock, Rick Schwartz, and Mike Farrell will present the case. Seth?
Good morning, Mr. Chairman and members of the board. Today, the staff is presenting for approval a final rule that will implement Section 18A4 of the FDIC Act, which prohibits any person from making false or misleading representations about deposit insurance, or from making or from misusing the FDIC's name or logo in a manner that would imply that an uninsured financial product is insured or guaranteed by the FDIC. This proposed final rule describes the process by which the FDIC will identify and investigate conduct that may violate this statutory provision, the standards under which such conduct will be evaluated, and the process by which the FDIC will formally and informally investigate and enforce this provision. The FDIC has historically worked to protect consumers by limiting the use of the FDIC's name and logo to insured depository institutions, and by preventing false and misleading representations about the manner and extent of FDIC deposit insurance coverage. Although the FDIC has broad statutory authority to pursue administrative enforcement actions against any person who misuses the FDIC's name or logo or who makes misrepresentations about deposit insurance, the FDIC has never issued specific regulations regarding how and when such actions will be pursued. In recent years, the FDIC has observed an increasing number of instances where financial service providers or other entities or individuals have misused the FDIC's name or logo on their websites or apps. The FDIC has also observed instances where entities or individuals have made false misrepresentations regarding the existence, extent, or effectiveness of FDIC deposit insurance in an effort to steer prospective customers towards alternative uninsured products. Such conduct can mislead and harm bank customers and undermine confidence in the United States banking system. Historically, the FDIC has responded to these situations in various ways without a formalized process or procedure. To provide transparency into how the FDIC intends to address these situations, going forward, last year, the board issued a notice of proposed rulemaking for public comment that proposed procedures by which the FDIC would identify and investigate conduct that might violate Section 18A4. I will now turn the presentation over to Rick Schwartz, an attorney in the policy unit, to talk about the comments we received and the modifications we've made to the proposed rule.
Morning. The FDIC received 19 comments in response to the NPR. Comments included national and trade associations, advocacy groups, one IDI, and other interested parties. All of the commenters expressed support for the proposed rule. Some commenters noted that they had observed similar trends of misuse in the industry and applauded the FDIC's efforts to prevent false and misleading statements regarding deposit insurance. Several other comments related to a proposed section of the NPR which provided that if a non-bank entity makes claims regarding insured status of its products, the failure to identify the name of the IDI which will be receiving the deposits will be a material omission in violation of the rule. The commenters, mostly trade associations, recommended that the FDIC clarify or remove this provision because they argued, as proposed, it would constrain the dissemination of information by and about so-called deposit placement networks. They explained that the deposit placement networks may involve many IDIs, making it difficult to name with certainty the specific IDI in the network that will receive a deposit until the deposit is placed. After consideration of the comments received with respect to the proposed rule, staff have recommended adopting the proposed rule with certain limited changes. To accommodate the concerns expressed by the comments regarding the impact of the proposed rule on banks working with deposit networks, staff recommends amending the proposal by adding a new section 328.102B5. As Mike Farrell will explain in more detail, the final rule will allow such non-bank entities to identify the IDIs into which the consumer deposits may be placed in limited circumstances, rather than effectively requiring non-banks to identify the specific IDIs that will receive a consumer's deposit. I'll now turn it over to Mike Farrell.
Thank you, Rick. Good morning. The final rule will establish two subparts to Part 328. Subpart A, entitled Advertising and Membership, will contain the existing provisions of Part 328. Yes, thank you. And Subpart B, entitled False Advertising, Misrepresentation of Insured Status, and Misuse of the FDIC's name or logo, will contain the new regulations relating to the enforcement of Section 18A4. The final rule will prohibit misuse of the FDIC name and logo and misrepresentations about deposit insurance. With regard to misuse of the FDIC's name and logo, the final rule will prohibit any person from representing or implying that any uninsured financial product is FDIC insured. With regard to misrepresentations about deposit insurance, the final rule will prohibit any person from knowingly making false or misleading representations about deposit insurance, including that any uninsured deposit is insured, or the extent to which or manner in which any deposit is insured. The final rule will also provide illustrative but non-exhaustive examples of conduct that would violate these prohibitions. It is important to note that the regulation covers omissions as well as affirmative misrepresentations. One type of omission that is specifically addressed in the final rule relates to non-IDIs that advertise the availability of deposit insurance. If a statement is made by a non-IDI that represents or implies that an advertised product is FDIC insured, it will be deemed a material omission in violation of Section 18A4 to fail to identify the IDI with which the non-IDI has an existing business relationship for placement of deposits. If the non-IDI is working with deposit networks, the non-IDI can meet this requirement by identifying the deposit network and each IDI in that network. The non-IDI could maintain its own list of the IDIs in the network, or if the network itself maintains a current list of IDIs in its network, the non-IDI could provide a hyperlink to that list. Staff believes that this requirement is necessary to allow consumers to understand the extent and manner of the deposit insurance provided. The final rule will also establish a process for members of the public to submit inquiries and complaints about possible violations of Section 18A4. The FDIC will establish a dedicated portal for such inquiries and complaints on its public website. The final rule additionally sets forth the process by which potential violations of Section 18A4 will be investigated. The final rule delegates the authority to conduct such investigations to the General Counsel. Investigations under the final rule will generally be conducted in accordance with Section 10C of the FDI Act and the existing rules governing FDIC investigations. However, the final rule does provide a limited exception to the general rule that FDIC investigations are confidential, in that it allows the FDIC to publicly disclose the existence of an investigation if there is a risk of imminent harm to consumers. The final rule also authorizes the FDIC to notify other agencies when it discovers conduct that may violate laws or regulations within their jurisdiction. Historically, the FDIC has generally resolved issues related to Section 18A4 informally. The final rule provides a process for informal resolution that is similar to what the FDIC has used to date. The final rule also sets forth the process by which the FDIC will pursue formal enforcement actions. The FDIC may pursue such actions if attempts at informal resolution fail or where there is a risk of harm to consumers or the public. Formal enforcement actions will be brought under Section 8 of the FDI Act in the same manner and governed by the same rules as FDIC enforcement actions against IDIs or their institution-affiliated parties. Finally, the final rule includes a specific provision providing that nothing in the rule bars any action provided by any state or federal law or regulation to any federal or state agency or person. This reservation of authority is consistent with the statutory language of Section 18A4 and complementary to the FDIC's authority to notify other agencies of conduct within their jurisdiction. With that, I will turn this back over to Seth.
Thank you, Mike. At this time, FDIC staff recommends that the board approve and adopt for publication in the Federal Register the final rule on misrepresentation of deposit insurance. If adopted, the final rule will take effect 30 days after publication in the Federal Register. We thank you for your consideration of this matter, and we welcome any questions that you may have.
Well, thank you very much. That was very helpful. I have a brief statement that I'd like to read, and then I'll turn to the other members of the board. The FDIC Board is considering today a final rule to address false advertising, misrepresentation of insured status, and misuse of the FDIC's name or logo. Section 18A4 of the Federal Deposit Insurance Act prohibits any person from engaging in false advertising by misusing the name or logo of the FDIC or from making knowing misrepresentations about the existence of or the extent or manner of deposit insurance. For insured depository institutions, enforcement rests initially with the bank's primary federal regulator, and the FDIC has backup enforcement authority. The FDIC also has enforcement authority for non-bank entities. In recent years, the FDIC has observed an increasing number of instances where firms or individuals have misused the FDIC's name or logo or have made false or misleading misrepresentations about deposit insurance. For example, the FDIC has seen a number of instances where scammers have made false or misleading assertions that their products offer the protections afforded by FDIC insurance. We have also seen circumstances where certain non-banks were making unsubstantiated claims about deposit insurance. These practices not only harm those who are targeted with the false promise of deposit insurance, but if left unchecked, could also undermine confidence in the FDIC, FDIC-insured banks, and the U.S. banking system. Today's final rule is an important step to protect consumers by providing transparency about how the FDIC will curb false or misleading advertisements about deposit insurance and misuse of the FDIC's name and logo. Historically, while the FDIC has routinely acted under the statute to protect consumers by limiting the use of the FDIC's name, seal, and logo to insured depository institutions and preventing false and misleading representations about deposit insurance, the FDIC until now has never issued specific regulations addressing false representations related to deposit insurance or the misuse of the FDIC's name or logo. Today's final rule provides clarity about the process by which the FDIC will identify and investigate conduct that may violate the statute, the standards under which such conduct will be evaluated, and the procedures which the FDIC will follow when taking formal and informal enforcement actions to address violations of the statute. One important aspect of the final rule is the steps it takes to address situations in which non-bank entities make unsubstantiated claims about the availability of deposit insurance. In particular, the final rule requires non-banks to support those claims and identify the bank or banks with which they have existing business relationships and into which consumers' deposits may be placed. This information can play a key role in enabling consumers and the FDIC to evaluate the accuracy of these claims about deposit insurance. The final rule also creates a process by which institutions and members of the public can report suspected instances of false advertising, misuse, or misrepresentation regarding deposit insurance. Given the proliferation of these issues in recent years, it's vital that the FDIC utilizes all the tools available to identify and address these situations. In conclusion, the final rule is an important step to address growing misuse of the FDIC's name or logo and false or misleading representations about deposit insurance. I believe this rule will protect not only consumers, but also FDIC-insured banks and the U.S. banking system by better enabling the FDIC to prevent false or misleading statements and misuse of its name and logo in a manner that could undermine public trust and confidence. I would further note that while the rule adopted by the board today is an important step, the FDIC is also considering revising and clarifying the agency's official sign and advertising rules related to FDIC deposit insurance. The FDIC official sign and advertising rules were last significantly updated in 2006. In that time, it has become more challenging for consumers to know when they are dealing with an insured institution and that their money is safe in an insured product. Last year, the FDIC issued a request for information on this subject. I expect that later this year, the FDIC board will consider a proposed rule to update the sign and advertising requirements to account for the changes in how insured institutions offer products and services to consumers, including through digital channels. Upon completion, I believe these complementary rulemakings will enhance consumers' awareness of when they are doing business with an insured institution and when their money is insured. I would like to thank the FDIC staff for their thoughtful work in bringing this final rule to the board today. I believe it's an outstanding contribution, and I am pleased to support this final rule. I'll now turn to the other members of the board. Director Sue.
Thank you, Acting Chairman Grunberg. I support the final rule implementing the FDIC's statutory authority to prohibit any person or organization from making misrepresentations about FDIC deposit insurance or misusing the FDIC's name or logo. The final rule describes the process by which the FDIC will identify, investigate, and evaluate potential violations of the statutory provision, and the procedures the FDIC will adhere to when formally or informally enforcing the provisions. The transparency provided by the final rule benefits all parties and promotes stability and confidence in FDIC deposit insurance and the nation's financial system. This final rule is timely, given changes in the marketplace, technological developments, and rapidly evolving consumer behaviors. It is especially important in light of the growth of non-bank crypto firms and fintechs and their relationships with banks. The potential for consumer confusion about the status of cash held at these firms is high, and this final rule will help provide clarity. It requires these firms, when highlighting the FDIC's name or logo, or representing that cash held at the firm is insured by the FDIC, to identify for consumers the insured depository institutions with which the firm has a business relationship and into which the consumer's deposits may be placed. This information empowers consumers and allows them to make more informed decisions when interacting with non-bank crypto firms and fintechs. Finally, I will note that the risk being addressed by this final rule reflects the strong confidence that the public and financial industry have in FDIC insurance. During times of uncertainty, the FDIC logo provides reassurance and an important sense of stability as designed and intended. This is due to the tireless, behind-the-scenes hard work of the staff of this agency. I would like to recognize them for this. Thank you.
Thank you, Mike. Director Chopra?
Well, thank you, Mr. Chairman, and thanks for the presentation. I hope it's okay just to ask a couple questions for the record on this to be clear about really the scope of what we're doing and also what other consumer protection enforcers can do to make sure that they're also doing their part to protect the FDIC's name and logo. Let me actually just start by asking you, Seth, you did mention that there has been an uptick in what the staff has identified in terms of potential misuse of the name or logo. You know, without going into specific details or allegations, I wonder if you could just share a bit more about some of the circumstances that have come to your attention and the team's attention that show that this is maybe something that is a growing problem, and how what were some of the ways in which you addressed it?
Certainly. I'm going to turn this question over to Rick Schwartz. Rick has historically been the individual who has spearheaded our responses to these sorts of complaints.
Yeah, thank you for your question. Yeah, as Seth indicated, I've been working on this pretty much from the time the statute was initiated, I think in 2008. And to show you how long this has been in play, our original complaints were against deposit brokers who had newspaper ads. And they would say, you know, in huge font, FDIC insured, and maybe in small font say that they're not a bank or they're a deposit broker, maybe they wouldn't even do that. And that actually led to our first enforcement action. But I guess fast forward to where we are now, in terms of the developments, we basically have three kinds of cases under the statute. The first is just fake fraudsters who have websites that are not real. And what we do in those cases is we work directly with the internet service providers to have those taken down. The second is probably touching on your question. Once fintechs have started, you know, they're good products, but they don't necessarily understand the connection between their product and the FDIC insurance with the IDIs that they work with. So I've worked with quite a few fintechs and written them letters and worked with them to make sure that they adequately explain that the insurance that they were offering was not through the fintech itself, but was through the IDI. You know, this is going to continue to go forward as fintechs evolve and other products come to the market. The third real area, and Chairman Grunberg touched on it, are people that just say incorrect things about deposit insurance in general. Most notably, we dealt with some gold brokers, and I can't get into names, but you know, they would argue that FDIC insurance was not safe, was not predictable, and therefore you should go buy gold or other precious metals. So this is something, you know, we have seen an uptick. We've seen an uptick in terms of the number of fake institutions. We certainly have seen an uptick once fintechs have started in terms of basically missing the boat in terms of what's covered under deposit insurance and what isn't.
Well, I appreciate that. And I also just want to echo something that the acting comptroller said, which is that, you know, many people are continuing to learn with respect to crypto assets that something may not actually be stable. And they may actually have a view that it's equivalent to a deposit in an FDIC insured account, and it's not. So I appreciate the work that has been done with this. I want to just make sure we talk a little bit about the enforcement mechanisms. So just want to be clear on one point. So if an IDI is making misrepresentations about this, or one of their institutionally affiliated parties, the remedial structure would be to pursue an administrative action. And for a non-bank that is not an institutionally affiliated party, the statute does allows the board to go to federal court to enforce that. Is that right?
So under the statute, we are allowed to go to pursue an administrative remedy against both banks and non-bank entities. So we could actually bring a non-bank entity in to a hearing before an ALJ. And Section 18A4 allows us to pursue those actions under Section 8 of the FDI Act, and those actions are brought administratively. Now, ultimately, after an ALJ issues a recommended ruling, the matters are presented to the board for a final ruling, and then those can be appealed to federal court. But as an initial matter, they will be heard by an administrative panel.
Well, I appreciate that because this is an important point that the board cannot immediately go to federal court, cannot seek the full range of legal and remedies that a federal court can offer on first instance. And I raise that because some of the conduct at issue may also violate other statutes as noticed in the rule. So I also want to make sure it's clear for the record that there are other statutes which prohibit related conduct. And so I want to ask you, Seth, just to make sure it's clear that how does the rule ensure that it doesn't prohibit other enforcers from going to federal court as appropriate, seek preliminary injunctions, seek legal remedies and equitable remedies?
Absolutely. We recognize the vital role that's provided by other state and federal regulators and by state attorneys general. I myself came up from the North Carolina Attorney General's office working on consumer protection matters there. And we wanted to make sure that we were very clear that this rule did not preempt or prevent other regulators from protecting consumers under their own statutes. Specifically, Congress, when it drafted Section 18A4, included a preservation of authority clause that made it clear that Section 18A4, while it gave the FDIC the ability to pursue these matters administratively, did not prevent or preempt any other laws that would impact other regulators or individuals. So if you have a private right of action for false statements, individuals can also pursue their own claims. When we drafted this rule, we thought it was important to mirror that statutory language, that preservation of authority language in the final rule. So just for the sake of clarity. And so we've now inserted a new provision in this regulation, which expressly states that it will not prevent any other federal or state agencies or individuals from pursuing claims under any other laws or regulations.
Well, good. That's important. And I think it's also important that it's clear, and I might ask you to react to this, that inasmuch that the FDIC is undergoing an administrative proceeding or going through an informal process to, change behavior of, potential misconduct, that this would not be preclusive of any other enforcer going to federal court to seek preliminary relief or exercising their own enforcement jurisdiction, which in some cases may have a broader remedial toolkit than we have here.
Absolutely. This rule is intended to supplement our authority. It's not intended to preempt or prevent any other regulators from taking actions that they see fit or necessary to protect consumers.
Well, good. I will encourage the staff then when you identify these, in as much that it is worthwhile to coordinate with states or others to make sure that the conduct is stopped and that when appropriate, there is the appropriate redress or other penalties that we will, of course, all support those efforts to do that because as the two colleagues said, it is important to protect the name and logo.
Director
of the
Chopra, if I can
FDIC.
just add
Yes,
that,
please.
that to date, we've worked with state regulators and the Federal Trade Commission on various ones of these nature.
Yes, and I'll share that it was very useful when the agencies worked with the FTC, I believe in 2020 on the Beam financial matter, which is one where that conduct needed to be stopped. There was claims about 24/7 access to money, which were false. And I think there was ways in which to move quickly to stop that. So we appreciate that. I'll share my formal statement now. Today, the FDIC Board of Directors is voting on a final rule to implement procedures regarding the Federal Deposit Insurance Act's prohibition on false advertising through the misuse of the name or logo of the FDIC or making knowing misrepresentations about deposit insurance coverage. I'll vote in favor of the final rule to strengthen the FDIC's ability to identify and investigate potential violations of this prohibition, to take enforcement actions against such violations, and to protect the overall integrity of the Federal Deposit Insurance Framework. In conjunction with our vote today, the Consumer Financial Protection Bureau is also issuing guidance to consumer protection enforcers outlining how misrepresentations about deposit insurance, even those that are not knowing, may violate the Consumer Financial Protection Act. Federal deposit insurance administered by the FDIC has instilled confidence in our nation's banking system for nearly 90 years. Depositors get the peace of mind that their insured funds are safe and secure, even if their bank should face financial trouble. The public's trust of federal deposit insurance and the FDIC has promoted a stable banking system by reducing the chances of destructive bank runs. FDIC insurance is a privilege, and insured institutions that repeatedly violate the law or otherwise engage in unsafe and unsound practices can have their eligibility for FDIC insurance terminated by the board. Some market participants may seek to illegally profit off the trust conferred upon FDIC insured products and services by enticing people and businesses through deceptive advertising and misrepresentations about federal deposit insurance. These lured individuals may unexpectedly lose money when they find that their assets are not federally insured in a time of financial distress. Honest banks and companies that truthfully market FDIC-insured accounts are competitively disadvantaged when competitors employ false advertising and marketing. The spread of a pernicious and illegal marketing can undermine confidence in the integrity of our nation's deposit insurance framework. In 2008, Congress amended the FDI Act to prohibit any person from engaging in false advertising by misusing the name or logo of the FDIC or from making knowing misrepresentations about the existence of deposit insurance. The statute provides the FDIC authority to investigate and take administrative enforcement actions against any person who violates the prohibition. While the FDIC has enforced this prohibition, it has never issued specific rules. And the regulation that the board is voting on today provides procedures for identifying and investigating such conduct, as well as for formally and informally enforcing the prohibition. The regulation also provides standards to evaluate potential violations, establishes a point of contact responsible for receiving complaints, and directs consumers to where they can obtain information or verification about deposit insurance coverage claims. Misrepresentation claims about deposit insurance are particularly relevant today. FDIC staff has noted an uptick in potential violations in recent years. We are especially concerned about potential misconduct involving novel technologies, including stablecoins and other crypto assets. While new technologies may yield benefits for households, workers, and small businesses, they nonetheless pose risks to consumers who may be baited by misrepresentations or false advertisements about deposit insurance. Importantly, while today's regulation expressly reiterates the FDIC's authority under Section 18A4, it does not bar any other action authorized by law or regulation by the FDIC or any other agency. The CFPB has a number of responsibilities to protect the marketplace from consumer abuses and unfair competition when it comes to deposit accounts, including rules regarding institutions offering uninsured deposit accounts and disclosures to depositors about their accounts. The CFPB is supporting the FDIC's efforts to root out misrepresentation by issuing a Consumer Financial Protection Circular. The circular indicates that covered persons or service providers subject to the Consumer Financial Protection Act likely violate the statute's prohibition on deception if they misuse the name or logo of the FDIC or engage in false advertising or make representations to consumers about deposit insurance. The circular notes that such conduct may violate the Consumer Financial Protection Act regardless of whether such conduct, including the misrepresentation of insured status, is engaged in knowingly. For example, the circular states that claims that financial products or services are, quote, regulated by the FDIC or, quote, insured or, quote, eligible for FDIC insurance are deceptive if those claims expressly or implicitly indicate that the product or service is FDIC insured when that it is not in fact the case. Our federal deposit insurance framework safeguards the hard-earned money of individuals, families, and small businesses. It also underpins the stability of our banking system. Today's actions by the FDIC, as well as the circular issued by the CFPB today, clarify and improve the agency's authorities to ensure that the integrity of our federal deposit insurance framework is preserved and protected. And I encourage all enforcers with relevant jurisdiction, including at the state level, to take this issue seriously. And again, thanks to everybody for all the engagement on this issue and all the work, and I'm pleased to support this.
Well, thank you very much. If there are no further comments or questions from the board, may I have a motion with respect to the request to approve the final rule on false advertising, misrepresentation of insured status, and misuse of the FDIC's name or logo?
So moved.
Thank
Second.
you. I'll just note there was Director Sue who made the motion and seconded by Director Chopra. I'll now call the roll for the vote on this matter. Director Sue?
Aye.
Director Chopra?
Aye.
And I will vote aye as well. The motion is adopted. Is there any new business for today's meeting? If none, that concludes the agenda for today. Thank you all very much. And the meeting is now adjourned, and we'll move it into closed session. Thank you all, particularly thanks to the staff for their excellent work on this.
Thank you, Mr. Chairman.
Thank you, Chairman and Directors.